Suspended police officer Musa Waga Kunene's bail application has been dismissed by the High Court. Kunene has been charged with the offence of theft by false pretenses. Now, the bail application proceeded before High Court Judge Ticheme Dlamini. Here's a detailed report.
The bail hearing of Musa Waga Kunene, suspended police officer, resumed before High Court Judge Ticheme Dlamini at the High Court. Kunene was arrested by Mbabane police on the 6th of July 2017 and was subsequently charged with the offence of theft by false pretense. Through his lawyer Sabelo Bembe, Kunene in his founding affidavit argues that even though he is out on bail on a similar charge, that cannot be a ground to refuse him bail, as there was no condition that he should not be charged or found to have committed a similar offence whilst out on bail. Kunene was granted bail by the Supreme Court on the 30th of June 2016. Kunene told the court that he will plead not guilty to the charge he is facing and that he will not interfere with investigations and that he will not do anything that will jeopardize the proper functioning of the criminal justice system. The applicant states that he has 3 school-going children who reside with his mother at Mvagweliche while he stays with his wife at Ngoyoyo. His wife works in Baban while he is a police officer on suspension following allegations of theft against him, for which he is currently out on bail. For the above reasons, the applicant pleaded that he has strong family ties in the country and is not a flight risk. When opposing the application through Crown Counsel Bonsile Ndlela, the Crown argues that the applicant breached the bail condition issued by the Supreme Court and that he should not be found to have committed a similar offence whilst out on bail, even though the applicant denies that that was part of the bail conditions. The Crown says it will not be in the interest of justice to release the applicant on bail as he has committed another criminal offence whilst out on bail. The applicant is now seeking bail for the 3rd time in respect of new charges. The Crown says the applicant was granted bail by the Supreme Court in respect of 3 charges, namely contravening of the Prevention of Corruption Act, extortion, and contravening of Money Laundering Act. The court found that the applicant appeared for bail hearing before the Supreme Court already out on bail for other offences: 1 count of defeating or obstructing the ends of justice, 1 count of contravening the Prevention of Corruption Act, and 3 counts of contravening the Pharmacy Act. These offences were all committed on the 15th of May 2015. The Crown's argument is that the applicant has failed to disclose the pending charges in respect of the offences committed in May 2015. Yet, Section 96 of the Criminal Procedure and Evidence Act of 1938 requires that an applicant for bail must disclose to the court whether there are any charges pending against him or her and whether the applicant has been released on bail in respect of those charges. In its judgment, the court said it was satisfied that it would not be in the interest of justice that the applicant be admitted to bail because the applicant has been granted bail by the court twice and is appearing before court for another bail application on a new charge. All the charges that he is facing are still pending in court.